Welcome back. As you know, we have been following for the last 6 months the case of Charles Chase Merritt for killing, allegedly, initially, the McStay family, all four of them, mother, father, 2 children, 4 and 3. But then he got convicted. He got convicted, and it's a death penalty case in California. Well, earlier we heard the defense give a press conference about Charles Merritt, about the McStay family. And what did they tell us? Let's listen. So that was obviously not the presser. That was actually part of the closing argument in the death penalty phase. That was Attorney Moline, who's just been a wonderful advocate for his client. What he basically said, and I have the expert here sitting right next to me, is that their expert found foreign DNA. It turns out 3 different types of profiles on the cord that we're using to wrap in the crime scene, the bra of the mom who was killed, and that their expert, Dr. Perling, who does not use True Allele, but he put it in form of CODIS, and then the state wouldn't enter their database. Who's right? Terry?
Well, so this is where it gets really complicated, right? Like we were talking about before, when we talk about small amounts of DNA and mixtures of DNA, it's very hard to get the kinds of answers that juries want, right? A jury wants to know whether something matches. And
but what about the fact that the state won't even run it?
I think that's problematic, right? And it's a different question, right? It's one thing if a state is using evidence to include someone, right? That takes a really high standard. You have to be really careful if you're using questionable forensics to put someone in prison for life, or in this case, to execute someone. It's a different question if, as the defense, you want to say, I think that I can raise doubt. I think that I can maybe even try to exclude my person. And if the state is not engaging in that, then they're engaging in something that is profoundly unfair.
And then Roger Foley, how are you? I know we've been on before, my amateur boxing championship. I mean, you know, in the courtroom, you are probably fabulous, okay? But let me ask you this. The jurors still heard there was foreign DNA at the site, and no DNA came back to the man they just convicted of a death penalty murder. It almost sounds like what we were talking about with the case before, the Central Park 5 or Jeff Descovich.
It's unfathomable. They're hearing this evidence. The death penalty case, they need to make a decision whether or not they're going to recommend life or death. You're just hearing about it now, and it's scary and it's bothersome. And your guest is absolutely right. This information is pertinent, and the prosecution should be putting it into their database to find out who those 2 or 3 other parties are where the DNA was in the graves.
Well, you know, I want to listen to more of the defense closing argument in the penalty stage, because it certainly was very emotional, just what we heard from Mr. Moline. Let's see if he talks even more about the DNA or other things. You know, when we try cases, defense attorneys, what happens is we get emotionally involved. And you saw Moline there. He is almost ready to cry. He's sweating. And usually, Roger Foley, again, my boxing championship from Florida, usually in a death penalty case, the jury weighs the aggravating factors versus the mitigating factors. That's what the attorneys usually argue on. But here, Moline, he's not even talking about the mitigating factors. He's saying, okay, we respect your verdict, but you have it wrong. And please reflect upon this. Do you think that strategy is a good one?
It's a tough strategy because the jury's already made a decision. You know, he's attacking the prosecution, which in effect is attacking the jurors. And it's scary. Maybe, again, he's doing his defense, but I'd probably back off and be more concerned with the mitigation to try to get my client not to have the death penalty on the table while the appellate process proceeds.
I know, but let me just ask you, Terry, you know, just generally, when you do a death penalty case, the jurors are supposed to deliberate, but they're not supposed to deliberate against each other. They're supposed to deliberate, talk about it, but make their own decision, unlike, you know, a group pressure when they're coming to a verdict. And when I tried a death penalty case as a prosecutor, we were at the stage that we just said, here it is, you guys decide. We're not making any recommendations to you. I actually had a juror who peed her pants, okay? She got it from the thing, and the chair was all wet. It's tough for these jurors, or should be, shouldn't it, isn't it?
It should be extremely tough. And I've been fortunate to be a New York State practitioner, and we don't have the death penalty in New York. So the idea of having such the ultimate punishment, and as a lawyer representing someone who's facing that ultimate punishment, and to be a juror in that situation, you know what? You should be peeing your pants over that. If you're not peeing your pants over the decision whether to kill someone or not, then you shouldn't be on that jury. That's how it should be. Every juror should walk away, maybe not with wet chairs, all of them, but should have that feeling. You shouldn't make that decision to put someone to death unless you have gotten to that point and have that feeling.
Yeah, and Roger Foley, you know, that brings up a question that I've been asking all week. You know, if you commit a murder or a homicide now in New Jersey or New York, there's no death penalty. But you go to Florida and Texas, there's still a death penalty. Where is the fairness? We have a United States of America. You know, where's the fairness? Let's assume that everybody in the death row is guilty, which we know that's not the case. But you know, in some states you get to skate and you get to live. In other cases, you get to, you know.
It's difficult. I mean, you cross over the line, as you say. You cross over the border from state to state, and the rules are different. There's no uniformity, and we really do need uniformity. And what your guest was saying about the seriousness of choosing life or death for an individual is an extremely difficult thing to do, and it should be. And I 100% agree with it.
You know, I think, and this we can all agree. We're going to tone it down just a little bit now because it's been a rough half hour, a tough half, not rough, but tough half hour, emotional. We're going to take a quick break and we'll be right back. Okay, my favorite defendant of all time, if you could say that in a courtroom, Roger Foley. You were a member of the Alabama Crimson Tide football team also. So let me ask you this, okay? Looking at it from a person who's been in sports and has seen rough and tumble things, and you've seen rough and tumble people, would you have put this defendant on the stand to explain himself, given his tone and his appearance?
Probably not. I just listening to him speak, it's just so distant, and to imagine, you know, going in late night at a Walmart to get cold medicine for the wife or family, and running into him while he's looking for a dolly and duct tape to chop his dad up. I mean, it's gruesome, and it's difficult to watch. And we're going to see at 3 o'clock what Judge Johnson does, but I'm expecting a pretty severe penalty. Well,
as a matter of fact, Terry, the decision to put him on the stand, we were all saying before, we never put our clients on the stand because it can do more harm. And then when his attorney, Elizabeth Ramsey, who represented Christopher Vasada in the case we were covering this week also, put him on the stand, we were all shocked until he testified. And little by little, we were like this. I think I believe him. At least some of us were like, I was like that. Would you have put him on the stand?
Well, I'll say the first thing is it's not up to us, right? It's up to our client.
Wow, yeah.
It's the client's decision in every case whether to testify on their own behalf or not.
That.
The hope as a lawyer, right, is that you're going to have a relationship with your client where you're guiding them to a decision that's in their best interest. But that is the client's decision. And I have to say, I would hope and I expect, given the way it seems like this attorney litigated this case, that she was close with her client, that she did have a good relationship with him, and that they were communicating. Because you don't get storytelling like that is rich with detail, that has a real ring of truth, unless you have prepped your client very well to testify. And it seems like Ms. Ramsey really did in this case. And ultimately, sometimes you don't agree with your client, and sometimes you're wrong, right?
Yeah.
Just because you're a lawyer doesn't mean that you all of a sudden know your client's life better than your client. And especially if you're practicing in communities that you're not from as a defense lawyer, don't think that you know the jury pool that you're in front of better than your client does.
Right.
And so those are really important things to consider. Now,
I'll tell you what, hold that thought, because I want to have you both listen to another clip where he's going to describe, and the good thing I'm not Michael Bryant, because Michael Bryant would have brought in props, chopping up the body of his dad. Roger Foley, I'm going to go to your strength again, because you were a boxer, because you were a football player. Go Bama, right? Hi, that's it, Joe Namath. You know, my quarterback from, because I'm a Jets ticket holder. You know, he's my guy, so I know he went there. But let me just ask you this, okay? I felt the ring of truth there when he said, you know, Dr. Mote said it was easy, but oh, is it difficult? What did you feel?
You know, I thought he came across, well, he came across as odd, but they spent so much time on the direct, right? What are we taught on cross-examination? Is to tell the story. They got to really tell the story on direct. And I think a lot of the reason why he wasn't convicted was because maybe the cross didn't tell the prosecution's story. It asked questions and he was able to fend off. And it wasn't the prosecutor saying, well, it happened like this, it happened like this, and pushing their theme on the jury. Because the direct took a lot longer than what you would normally have, I think that they focused on that and they believed the details about the shopping and the room and the getting into the kitchen and the space.
Right,
and because that was believable, they believed how he died.
And Terry Rosenblatt, again, I think Roger makes a good point that you have to tell a story in a trial, and that he was odd, and the oddness looked like he could be the kind of person that did this, right?
Or he could be the kind of person who didn't do it. And obviously that's what the jury weighed, right? And remember, too, when a defendant testifies, it doesn't become a he said, she said, right? The question for the jury doesn't change from did the prosecutor prove their case or not to which side proved their side, right? So the prosecutor still has the burden. The prosecutor still has to prove their case. And by the defendant testifying in this case, they made that a lot harder by having this richly detailed story from a person, and you could see the lump in his throat when he's testifying.
You know what? We're going to see more of him. We'll be back to discuss more of him. But remember, he's going to get sentenced at 3 o'clock today on this network. We'll be covering it right now. Right now, though, a short break. He is going to be sentenced at 3 o'clock for dismembering his father. He can get up to 15 years, and I understand many members of the family will be there to speak at the pre-sentence, and not in his favor. Roger Foley, when you listen to him and you look at this, what do you expect the kind of sentence will be if it's up to 15 years?
I anticipate a very strong sentence. You have a guy talking about dismembering his father. You have a man who's talking about evading taxes. You have a man who talks about selling drugs. And obviously he was found not guilty, but I expect a strong sentence. He's facing 15. I would think 10 to 15 would be likely. If he gets 10, he'll probably get 5 more in probation.
Thank you, Roger Foley. I have to sign you off now. Thank you for being with me. I know you're going to be watching, and we'll talk about it in the future. Quickly, Terry.
Thank you so much, Lynn.
I know you just seeing him for the first time. Impression about whether the judge is going to sentence him for a murder, even though he wasn't acquitted, even though he was acquitted of the murder?
Well, he really shouldn't, but I think it's going to be very hard for the judge who presided over the trial to separate those two things, and it'll really be on the defense lawyers to hammer home to that judge that he cannot be sentenced for a crime he did not commit.
Well, stay with us, because right after this break, we're going to watch the courtroom and see whether the sentencing will start.